This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about an age-old problem. Lies on an application for insurance will void the policy of insurance, and an insurance company can avoid liability on the policy simply by showing that the insured represented and misrepresented a material fact, because rescission is a remedy for fraud in the application for insurance. Beach Cruiser LLC and Flyway Management LLC own and manage multiple rental units. In 2021, Plaintiff Mt Hawley Insurance Company issued defendants an insurance policy. The policy covered bodily injury liability in connection with their units, but excluded coverage in the event the defendant provided, quote, incorrect, false, inaccurate, or incomplete information, close quote, in their application for insurance. In the case called Mt Hawley Insurance Company versus Beach Cruiser LLC et al., the United States District Court for the Southern District of New York on March 6, 2025, applied New York's law concerning rescission. The facts were that Plaintiff Mt Hawley is an insurer and Defendant Beach Cruiser LLC owns multiple residential properties and rents them out to tenants. It owns a residential property located at 146 Pleasant Street, Unit C in Charleston, South Carolina. Defendant Flyway Management, together with Beach Cruiser, manage the property on behalf of Beach Cruiser at all relevant times. Non-party USI Insurance Services served as an insurance broker for Beach Cruiser with respect to the policy. Defendant's application for the policy checked no in response to the question, quote, are any properties rented by the day or by the week, close quote. Contrary to the statement in the application, defendants had been renting some of their units by the day or by the week for years before they signed their application. On July 23, 2022, two of the tenants allegedly fell from the second floor of the property after a porch railing collapsed. Both tenants sought damages from the defendants for their alleged injuries. Defendants claimed coverage under the policy. Plaintiff argued that the defendants' claims are excluded from coverage because the defendants misrepresented the property's rental status in their application. The principal question, therefore, before the court was whether New York Insurance Law Section 3105 Pren B modifies the parties' agreed upon exclusion of coverage based on the defendant's misrepresentations. The court concluded that it does not. It does not apply, whereas in this case, an insured's claim is excluded from the insurance contract by prior mutual agreement, and a rescission basically means there was no policy at all. The policy included coverage for, among other things, bodily injury liability up to $1 million per occurrence, subject to the policy's terms and conditions. For purposes of the endorsement, quote, the applications include, without limitation, any application form and any other forms, documents, or information submitted to us in connection with or related to the issuance of this policy, and for purposes of this endorsement, The application is part of this policy and is incorporated herein. Close quote. Beach Cruiser checked no. In the box in response to the question, are any properties rented by the day or the week? However, Beach Cruiser had been renting the property through Vrbo, an online platform for short-term vacation rentals, since 2018. On January 25, 2022, Beach Cruiser executed a 3-day rental through Vrbo to a party to stay at the property. The party included Walter Patrick Humphrey and Jonathan Charles Slade. Mr. Humphrey filed an action in South Carolina State Court against Beach Cruiser and Flyway arising from his alleged injuries, and Mr. Slade sent Flyway a demand letter alleging various causes of action arising from his alleged injuries. On November 14, Mount Hawley sent Beach Cruiser a letter stating it was rescinding the policy. Summary judgment is appropriate in New York because the policy unambiguously excluded coverage in connection with the July 23, 2022 incident. There's only one reasonable reading that the court could find of question 3 in the application. Defendant's response to question 3 was plainly false, and the endorsement unambiguously excludes coverage if the insured provided false answers in the application. The policy unambiguously excluded coverage for defendant's claims. New York courts have held that where there has been a misrepresentation by an insured, the insurance company can avoid liability on the policy by showing that the misrepresentation was material, and because enforcing the endorsement according to its terms is not inconsistent with Section 3105 Paren B, close paren, the endorsement is not, as defendants argued, void as a matter of public policy. Plaintiff's motion for summary judgment was granted, and defendants and Nationwide's motion for summary judgment was denied. The court declared that Plaintiff Mt. Hawley Insurance Company had no obligation under the policy to defend or indemnify the defendants in connection with the July 23, 2022 incident. Accordingly, because the policy unambiguously excludes claims in the event of misrepresentation in defendant's application, and because defendant's application unambiguously misrepresented the rental status of the property, plaintiff's motion for summary judgment was granted, and defendants and Nationwide's motion for summary judgment was denied. In my opinion, insurance is a contract of good faith that requires each party to the contract to act fairly and in good faith to each other. When one party seeking insurance lies about the risks faced by the insured and the property that is the subject of the proposed insurance contract, he, she, or it has misrepresented a material fact, and the law of equity requires the policy to be declared void from its inception. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll gain access to the more than 5,000 blog postings, as well as getting notice of every blog posting, usually 5, sometimes even 6 blog postings a week. You can also subscribe to these videos at YouTube and rumble.com, and if you do, I'd appreciate you clicking on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.